All right, everyone. Hello and welcome to this edition of PON Live from the Program on Negotiation at Harvard Law School. My name is Nicole Bryant, and I'm the Managing Director at the Program on Negotiation. And as many of you know, the Program on Negotiation has for 40 years now led the world in research and curriculum development and executive education related to the fields of negotiation, mediation, and conflict resolution. And one of the things that we look forward to every year is the occasion to present the research findings of our latest crop of graduate research fellows. And every year we have a very competitive selection process for doctoral students from across the world to come and spend a year working alongside the faculty and researchers of the Program on Negotiation, attending and participating in our trainings, and being a part of our team. And so this year, we are pleased to celebrate the conclusion of the fellowships of two outstanding fellows that we've had with us over the course of this year. You will also see on our website that we have just announced our 3 upcoming fellows for the next academic year. So this is a lovely cycle of researchers coming into our orbit, and we like to celebrate the moment where they formally leave, even though, of course, we'll consider them a part of our community for a very long time. We count among our own faculty many former fellows who have come through this program and are delighted to see this legacy continue. So today we have our 2 2023-2024 graduate research fellows, Jared Miller and Juan Rivera-Rugeles, who are here to present their work. We have 1 hour with them today, and what we are going to do is set up a 2-part format. So first, we will have Jared and then Juan presenting. Each of them will take about 20 minutes to present their work, and then we will open up the floor to questions, first for Jared and then for Juan at the conclusion of each of their presentations. So of course, as ever, for those of you who are familiar, at any time, please feel free to drop a comment into the chat function of our Zoom. But if you have a question, we would ask that you put it in the Q&A at the bottom of your Zoom screen so that we can more easily streamline all of those questions that will be coming in, first for Jared and then for Juan. So that is the format for today's event. Thank you to everyone for joining us from all over the world. We love seeing you here and welcoming you for the next hour. And of course, this session is being recorded. So if you have to drop off early, or you want to send this to a friend who missed it, or Jared and Juan want to share with grandparents, friends, and other cheerleaders on their side, then they will be able to do so. The recording will be posted in just a few days on our website. All right, and without further ado, I'm going to introduce the first of our 2 fellows, Jared Miller, and invite him to join me on screen. Hello, Jared. So Jared is a PhD candidate at the Fletcher School at Tufts University. And in fact, as we were getting ready to start this, he was talking about how furiously he is in writing mode. So many people here have been in that space in their lives. We are wishing Jared lots of caffeine and, you know, some breaks out in nature every once in a while to clear his head and go to the balcony as necessary to keep on that final push of writing. So a PhD candidate at the Fletcher School at Tufts University, and his work focuses on the intersection of peace building, anti-corruption, and accountable governance. And in particular, he is looking at accountable governance in Nigeria, which is a place where he has worked extensively on the ground, and he's going to be telling us a little bit more about that in the course of his presentation. He's been a delightful part of the team throughout this year, and I'm very much looking forward to hearing his work. So without any further ado, I'm going to turn over the virtual Zoom microphone to Jared Miller.
Thank you, Nicole. Let me go ahead and share my screen. Okay. Thank you, Nicole, and thank you everyone for being here. And thank you to PON for supporting this research and welcoming me into the network. It's been a great opportunity to meet so many different people working in the field, both as practitioners and researchers. This kind of blend between practice informing research and research informing practice, I think, is a unique benefit of PON and something that's resonated a lot with my own work. So today, as Nicole said, I'm going to be presenting a little bit about some of my preliminary findings from my dissertation Peacebuilders, Politicians, and Brokers, the Politics of Transforming Conflict and Power in Nigeria. And I say preliminary because I'm still in the stage of doing validation interviews and writing. So I welcome any questions that you all have during this process. But to kind of start off, I thought it might be helpful to get a little bit of a backdrop of kind of where I'm coming from and what has really informed this research. From 2015 to 2017, I lived and worked in Nigeria in a northern city called Jos, where I was working to support local peace building efforts. This was an incredible opportunity to really understand the impact that these programs could have, but also the continued challenges. Some of the big questions that were coming back to me during this experience is, how do you start to create and foster accountable governance in a context where corruption is not only driving some of the conflict dynamics, but it's really undermining efforts to build that accountable governance over time? And these are the questions that took me back into grad school to try and understand what it is that could be done. What are new strategies that could be employed? What does theory tell us about improving practice? And as I dove deeper into the literature, a lot of this was pointing towards deep democratization, transforming relationships and social norms, key conflict transformation mechanisms. But environments characterized by systemic corruption and conflict, these processes are especially fragile and subject to co-option. So as I dove deeper into this material and having conversations with other researchers, Nigerian colleagues, in some ways I kind of arrived in some ways where I started, looking back at these local level peace building efforts, but reorienting the way in which I was examining them. And this brings me to the research question itself. I'm focused on whether or not and how these community-based peace-building efforts foster accountable governance in context of systemic corruption, and if so, how this actually happens. And most research on peace-building programs looks in effect at kind of what is the overall impact on the conflict dynamics? How does this change over time? Is it decreasing levels of violence? Is it able to prevent outbreaks of violence? And I wanted to take the next step of asking, how does this actually impact the broader political environment? So a little bit on my research approach and methodology. I began working on this virtually in June 2021, have continued to date, including a couple of months of fieldwork within Nigeria, really drawing on my previous 2 years of experience working in Plateau State. Within this, I draw on over 35 in-depth interviews, 7 focus group discussions with 45 people, and a trove of observational data and primary documents that I collected while there. As I said earlier, I'm in the process of doing validation interviews to validate my analysis and refined as I work on writing this. So to kind of jump in and kind of give a little bit of background about where my focus is within Nigeria. I worked primarily in Plateau State, which is this state here highlighted in the yellow outline on local level peace building programs within the broader Middle Belt region, which is this blue highlighted area of Nigeria. Plateau State's interesting because it's seen as both kind of a microcosm of Nigeria itself, but also a bellwether for the stability, the peace, and the democratic outcomes of the country. Nigeria has over 300 ethnic groups across the country, and within Plateau, you can find at least 50 different ethnic groups. The major groups in Jos, where I was based, include the Biram, the Anaguta, the Efizere, and the Hausa Fulani. Plateau State is also a microcosm of the broader economic environment within Nigeria. Across the country, over 62% of the population in 2022 was considered multidimensionally poor. Within Plateau State, this is actually above average, with over 84% of the population experiencing some sort of severe deprivation, most commonly in the form of nutrition, food security, or access to healthcare. Plateau State has also experienced a variety of forms of insecurity, ranging from communal conflict, resource-based conflict, to also banditry, kidnapping, criminal networks, and over the past 20 years, at times, experiences of violent extremism. One of the core issues that has really come to the fold within Plateau that you can find across its conflict dynamics is this question of indigeneity, the question of who is considered an indigene and who is considered a, quote, settler. This distinction comes from some of the colonial governance from the British prior to 1960, but it has also continued through present day legal structures. An indigene is somebody who can trace their genealogy to a particular geoethnic space within a local council or state in which she or he is a resident. A settler is somebody who moved to a place but can't necessarily trace their family history to that place. This becomes extremely challenging to do, as the records that people often turn to support claims of indigeneity or are the colonial records, many of which have major blind spots and have been manipulated. In modern day, this was enshrined within the Constitution to try and ensure representation at the national level, that the federal government looked like the diversity across the country. One of the challenges, though, is that indigene, while it's enshrined within the Constitution, it's never actually defined. So it leaves a lot of latitude for how this is actually who qualifies to become an indigene at different places within the country and who isn't. It becomes incredibly important because it determines who's eligible for certain government positions, chieftaincy titles, and access to land. To give a little bit of background of the conflict dynamics within JOS, specifically in Plateau State, and I won't go into too much detail here, but happy to talk more about it in the Q&A, is that the kind of spark for a lot of these conflict dynamics emerged in 1991 when the capital city of JOS was divided into two different local government areas, JOS North and JOS South, redefining who was the majority population in each and who had therefore claims and the ability to influence who would be considered an indigene and who would not. Specifically in JOS North, there's a lot of contention over who is considered having historical claim to that territory and therefore control of the government. Across the next 30 years, there would be outbreaks of violence, notably between 2001 and 2004, where there were cycles of violence, attacks and reprisal attacks, in which more than 5,000 people lost their lives and displacing over 250,000 people. This is violence specifically focused within JOS, but it would have repercussions across Plateau State and across the country. So some of this violence that is really rooted in some of these questions of who has claimed a certain rights and land within JOS, you can find these similar dynamics across the country, again, hinting at the fact that JOS is a microcosm of the broader country. These conflict dynamics have evolved over time and taken on different manifestations and ethno-religious coloring, but they've also merged with criminal violence stemming from kidnapping and armed banditry to competition between farmers and herders over access to shared resources in the 2010s. But where my research really focuses is on this point about how conflict really is an interaction between, quote, the political crisis caused by politics of money and resource competition taking place against a background of various predisposing factors. And I'll continue to go into this through the lens of responses from interviewees. But what I want to kind of present my preliminary findings through the view of is kind of three different areas that my dissertation takes its title from: the Peacebuilders, the brokers, and the criminal politics, and specifically the interaction between these and how we understand the impact of local level peace-building efforts as they intersect with broader political dynamics, but also some of the individuals that are involved in trying to complexify who we think of as the politicians and what their interests are, as well as the people that facilitate their election. So this first area is around the Peacebuilders and kind of what do we see as the impact of some of these sustained local level peace building efforts within Plateau State. And so by peace building efforts in this context, what I'm really focused on are conflict transformation trainings, problem solving workshops, and multi-stakeholder dialogues that try and bring people together and provide them with the tools and methods to resolve conflict through nonviolent means, but also in a stakeholder platform that really brings together diverse perspectives from across the community, but also people from different types of authority, from traditional institutions, community leaders, to different government offices, from the local level officials and the security networks. So what do we see actually coming out of this? Well, the first is, especially against such a fraught backdrop of horrific violence that often took on an ethno-religious dimension, we see these efforts as really being able to address and rebuild some of this tolerance and trust across communities. At the beginning of some of these peace building efforts, some of these stakeholders would not go into a room with one another because they saw the other as an enemy or, quote, involved in violence against their own family. So rebuilding the trust so that not only could they sit together and share what has happened to them over time, but also explain what they see as big things to work on going forward, emerging conflict dynamics that should be responded to, and then to work together to try and address them. And this really comes to the second big area that comes out of the research around the ability to facilitate cooperation, not just between the community members themselves who have historically been divided, but also across the community members and local security actors. For those that are familiar with Nigerian politics, many will know that in much of the country, security forces have a legacy of human rights abuses, creating fear within the community. So community members being reluctant to report things to security forces, and security forces being suspicious of the veracity of the reports that are coming from communities themselves. But out of these multi-stakeholder dialogues, interviewees consistently report that their relationship and trust with the local security actors has increased, so that not only are the security actors willing to pick up the phone when they call to report something, but they'll actually hear back about what the security actors did in response. This initial degree of a layer of accountability of, well, what do you actually do if I report something to you? What is the outcome, and then what is the next step? Going to kind of the second area, and this is really around what I would call the brokers and refer to as the brokers in the literature. And these are individuals often within the community themselves, but kind of facilitate this connection between community members and politicians, especially when traditional, more democratic means of connection aren't necessarily functioning. And one of the vignettes I want to offer here is really around the image of a local campaign organizer, somebody who is charged with whipping up votes during the election, and bringing people out to the polls to support a particular candidate. But here, one of the kind of fascinating things is, for those that are familiar with Nigerian politics, elections themselves, while Nigeria is a major proponent of democracy across the continent, and really opposed military dictatorships or presidents for life, internally, few of the elections have been fully free or fair. Many are marred by allegations of manipulation, voter suppression, and characterized by high levels of violence. And one kind of political party official, campaign official put it to me is, you have to understand how these processes work and how you win an election, even if you disagree with the actual mechanism, because you want to try and bring dividends back to your people. The idea of, you don't get to set the rules necessarily, but once you're in office, you might have the ability to bring some of the benefits of that office back to your people. But the kind of, to complexify this image a little bit, the brokers themselves were often articulating how negative they thought the rules of the game were. That while they were planning out how to buy votes in the upcoming election, that they wish they didn't have to do this, that they could actually spend the money to put on a debate among the candidates or invest that into more of a grassroots movement, but that they felt immensely opposed or up against immense challenges in taking that different approach, because that wasn't necessarily how the game was played. And this is really where it hits this other facet of the political implications, intersecting with the political dynamics of what community members frequently referred to as, quote, the criminal politics. And this is where they saw the intersection of conflict and politics, that the resolution or prevention of conflict wasn't necessarily in the interest of all politicians, because the outbreak of violence conflict generated resources. It allowed the government to justify spending certain budgets, emergency budget allocations that the politicians could then use for different avenues, including their own campaigns. And many of the community members that I spoke with and the peacebuilding practitioners said elections are one of the most tumultuous times in trying to build coalitions and build a sustainable peace, because it's treated as such a zero-sum game. Politicians are pursuing election in sometimes very negative regard. This quote of whipping up votes, using whatever tactics you can, including ethno-religious sentiment that really hit on some of the historical conflict grievances. But within this, there's also the challenge of the perspective of the politicians themselves, who acknowledge that they might be trying to employ some of these tactics to get into office, but then how they see the use of that office. One local government official described this saying, trying to touch people's lives, that once he was in office, he was using the resources to try and improve the lives of his constituents as he saw the ability to do so. The challenge with that is that who he was actually providing some of these benefits to weren't necessarily across his entire constituency. It was select groups that were connected to him, perhaps because of ethno-religious lines or patronage networks, creating grievances among those who weren't benefiting from his tenure in office. So this challenge of kind of both holding office, but then how that office is actually used for the benefit of the people. And so kind of what does this all mean, and kind of what does this actually tell us both about local level peace building programs and efforts, and kind of what that means for trying to improve the way that these are conducted in the future. Returning to my original research question, do these peace building efforts actually strengthen accountable governance in context of systemic corruption? And if so, how? And in my research kind of shows evidence of yes and no, that they can contribute to some what I would call building blocks that can lead to more accountable governance. These are the coalitions among community members that were once divided, coalitions between the community members and security forces trying to address and prevent outbreaks of violence, and coalitions that right now might be focused on preventing violence, but perhaps could be turning to a more political agenda to try and address some of these more structural drivers of the conflict. And that's kind of where one of the remaining challenges remains, that while these peace building efforts have been effective, my research shows in addressing some of these conflict dynamics and trying to prevent the outbreak of violence and build ongoing efforts to prevent the escalation of tensions to violent conflict, there still remains this challenge of how they intersect with the broader political sphere, when elections still employ some of these tactics that fall into the umbrella of, quote, criminal politics. And what does that mean for these coalitions going forward as they try and work to change what those dynamics actually are? And this is where I want to leave with two quotes from a participant, an interviewee, that I think really speaks to the importance of these coalitions, especially when thinking about the long-term impact of peace building efforts and what they might contribute to down the road in terms of accountable governance. That first, when you take power away from those who have long held it, it's not easily taken. This is where people need to hold the government accountable. And these coalitions offer some promise of a mechanism that might be able to do it. A continued challenge has been is how do you maintain a coalition in conditions of sustained precarity, defined both economically, but also in terms of outbreaks of violence. And that for people to be able to engage these leaders, they must be empowered to engage them, and they must be organized. And I think some of these efforts kind of show some evidence of ways in which that could happen. But with that, let me pause and open it up to question and answer, and anything that you all would like to discuss.
Wow, thank you very much, Jared, for this fascinating tour. And I think that we have all learned a lot. At least I know I have, and am left with a number of questions. So we will invite, of course, anyone who has questions from the group to submit them. And while recognizing that, given time constraints as ever, we were not going to be able to get to all of them. So the first question posed by Sanjay is about how to what kinds of structural changes you've seen through these efforts that could help keep, this government, or really any government in the same position, honest. Are there role model nations that you have seen work through similar challenges, or things that are being attempted in Nigeria that you would point to that have made some headway?
Thank you for that question, Sanjay. I mean, it's a great question. So one of the areas within the research that I think holds a lot of promise, especially within Plateau State, and the ability to learn a lot from it, is that Plateau State offers kind of a 30-year spectrum of peace building efforts. And kind of this latest stage is trying to take some of the programs that have been supported by international donors and actually institutionalize them into local structures in terms of local governance, but also as sustained volunteer coalitions within the communities. And this has a lot of promise of, once you structurally enfranchise a conflict resolution mechanism within the government and give it authority to try and proactively address these, to convene stakeholders, that has the real convening power, that when they send out an invitation to a government official that they'll attend, that holds immense promise. One of the continued challenges is that while these structures have been enshrined in law, something that's unique across the country, they've been provided very little budget, and they still rely on international donors for some of the budgets to bring together some of these stakeholders. And there are continued questions around, are these independent mechanisms now that they're in the government, or are they being politicized for the same criminal politics to benefit those in power? So some of these credibility challenges that continue to play out. So I think there's a lot of promise, but there's also a bit of a rocky road ahead. But great question, Sanjay.
Thank you, Jared. Next question from Lars, asking about the security personnel that you mentioned. So specifically, is there some kind of silver bullet to get these folks to be more proactive in their approach to conflict prevention?
A great question, Lars. And I would say there's no silver bullet, but kind of the research suggests that there are some common elements that would help support a more proactive response. One is security actors having adequate information about what's happening. And this in part comes back to connections and trust with the community, the ability to get quick reports from the community when something is happening, or in advance of something happening, knowing that tensions kind of are bubbling up and that a small flashpoint may escalate quite quickly. A second is, are the security forces themselves adequately resourced? And I mean in terms of equipment, but also payroll. Kind of the security sector, especially within Nigeria, is notoriously opaque and notorious for corruption. And so your active soldier that might be manning the checkpoint that you really count on for making sure that nothing's going on in your area, they may not have been paid in a month. And it's not through a fault of themselves. But what does that mean for actually their willingness to go and put their life on the line for something that they might not have full confidence of what's actually happening? So I would say those two factors really help promote a proactive response. But again, these connections and relationships across stakeholders, from my research, that is a hugely critical element.
Thank you. A question from Charles about a role, if there is one, for dispute system design in helping to cultivate relationships and consensus building in the work that's going on.
It's a great question, Charles. So couple of things that came out from my interviews with folks that have been part of these as community members, but also have been working on these for decades, are one, kind of the sustained interaction of people, the ability to have a relationship, to be able to call them and organize quite quickly and have the connections across the community so that they have the influence. But part of this was also the question of, do they have the capacity in terms of the resources to be able to devote the time to this? Apologies if you're getting some siren in the background of my mic. In terms of kind of efforts to devote time to this, means it's taking away from time that you're devoting to work, to your family, to meeting your daily needs. So what does it mean for somebody to be able to engage in some of these platforms, especially in broader conditions of insecurity and extreme economic precarity? So one of the pieces that frequently came through in interviews of when we think about these conflict dispute resolution, dispute resolution mechanisms, we need to also think about the fundamental economics of what it takes for somebody to be able to engage in this. Do they have a stable livelihood? Are they traveling kilometers to be able to engage in this dialogue or this platform? Do they have the minutes on their phone that they can start to call around the community? These are all economic costs that aren't necessarily always integrated when we think about the design.
Lovely. All right, Jared, I'm going to ask one last question, then we're going to turn it over to Juan. This is from Reynaldo, which is, you talked about indigeneity at the outset. Is there a role specifically for people who are able to prove this question of lineage, which seems so critical to this community, in being the peace builders or conflict resolvers specifically going forward?
No, that's a great question. And I would say from my own research, you do have people who have become outspoken proponents who they themselves are indigents and say, we need to rethink this. This is clearly not working. There is no mechanism if somebody for internal migration, for someone to move across the country and become ingrained in the community and have equal access to the rights and privileges of somebody of that community. And so you do have examples of people who are trying to lead structural changes in terms of legislation. But within the context of Nigeria, at the end of the day, this is a national constitutional question that there hasn't to date been enough support to put forth constitutional changes. And kind of this has served a lot of politicians' interest to leave this question unresolved, especially when you think that the rights and privileges, right now, the government does not have the resources to provide equal benefits and services across their constituency. So being able to select parts of that within their constituency does serve the interests of some politicians, especially when it comes to an election cycle. But again, not all politicians want that to be the reality and hope that would be the change. They just may have limited agency to change that themselves.
Wonderful. Well, thank you, Jared. And I know that there were other questions that we had. We've just put your email in the chat so that if we weren't able to get to anyone's question live, or if you'd like to continue the conversation with Jared Miller, you can absolutely do so. Since I'm sending you off into the either and into your dissertation, I will say best of luck in this phase that you're going through, and please keep us posted, and we'll see you, of course, at future PON events. Thank you very much.
Thank you.
Now I will go ahead and introduce our second fellow, who is Juan Rivera-Rugeles, and invite Juan to come on to our screen. So Juan is a SJD candidate right here at Harvard Law School with a dissertation on the interplay between anti-impunity and transitional justice discourses. And he is a Colombian lawyer who has extensive professional experience in Colombian government. He worked for an NGO, the Colombian Commission of Jurists, advised the Colombian Congress, and was a clerk at the Colombian Constitutional Court. So we are very pleased to have Juan here today to present his work as well. Juan, you have about 25 minutes. I know you'll spend most of that presenting. And then, of course, as with Jared, we will open the discussion up to further questions. So thank you very much. And the floor is yours.
Thank you, Nicole. Let me share my screen. Okay. So I would like to begin by thanking the Program of Negotiation for allowing me to be a graduate fellow this year. This recognition has been a fundamental support for continuing my research, which I want to share with you today. It is related to accountability, similar to Jared's dissertation. But unlike Jared's, mine is about atrocities for the crimes committed in armed conflicts, and it deals with the debates about negotiating or when negotiating peace agreements. So it goes a step behind or before Jared's, which is about peace building. Mine is about the stage of negotiations. So my dissertation has to do with peace negotiations and the international legal framework to end armed conflicts. In particular, I want to discuss the intense legal debates regarding the fight against impunity when negotiating peace agreements to end armed conflicts. I want to argue that although the international legal landscape has made combating impunity a red line in peace negotiations, is a line whose contours are still being drawn, with sophisticated legal experts leading the charge. Behind the slogan of the fight against impunity, the legal discussions about it give ample room for negotiation on the scope of criminal trials for the atrocities that occur in those situations. So my dissertation explores the discussions on impunity in the peace negotiations in Colombia between 2003 and 2016. I will present it in three parts. First, I will discuss the emergence of the fight against impunity as an issue of relevance for peace negotiations. Second and third, I will explain the reasons for choosing Colombia as my case study and illustrate debates on different interpretations of impunity. Considering the plurality of the audience, possibly interested in various aspects of negotiation, I will dedicate a little bit more time to present the first part and briefly mention my case study and some of my findings. So let me begin by explaining how the fight against impunity has been consolidated as a red line in peace negotiation, as a matter that parties cannot agree against. The core international human rights treaties signed in 1966 do not include the word impunity. Duties such as criminal punishment of those responsible for any serious human rights violations did not make part of those international instruments. However, since the late 1980s, NGOs started arguing that states should guarantee accountability by prosecuting and punishing those responsible for the atrocities. As an example of this view, in a 1989 policy statement, Human Rights Watch considered that although there might be some difficulties for new governments to guarantee prosecutions and punishments, those difficulties do not justify disregard for the principle of accountability. According to Human Rights Watch, public disclosure and condemnation might achieve accountability for the lesser responsible, but criminal prosecutions and punishment are necessary for the most responsible. Based on this reasoning, Human Rights Watch asserted that it opposed amnesties for gross abuses of human rights. And if you want to check that policy, you can take a look at the reference that I think is going to be dropped in the chat. Trying to translate this position into reality in situations where massive human rights violations have occurred present enormous economic, political, and moral challenges. It is not surprising then that alternative views regarding accountability emerged during that time, precisely when countries of the southern cone of South America were undergoing political changes out of military dictatorships, and something similar happened in the countries of East and Central Europe transitioning out of communist rule. In those places, politicians and scholars reasoned that accountability is indeed an essential goal for successful transitions. Still, they pointed out that there might be tensions between peace and justice in those contexts, so it is necessary to think of other mechanisms to fulfill that goal, such as truth and such as through commissions and reparations. For instance, writing in 1991, and this reference is going to be in the chat as well, a well-known human rights activist and scholar, José Salaquet, defended the Chilean transitional scheme as an adequate balance of accountability and reconciliation, prioritizing truth and reparations over redistributive justice, considering the political realities. Between the two views, accountability through criminal law has had a significant doctrinal and institutional development. At the doctrinal level, the leading human rights protection mechanisms have accepted the idea first put forward by the Inter-American Court of Human Rights, according to which the duty to prosecute and punish is part of the obligation to protect human rights. At the institutional level, the most emblematic achievement is the establishment of the International Criminal Court pursuant to the Rome Statute signed in 1998. These legal innovations have led human rights organizations and academics to resist the use of amnesties for atrocities, even in negotiations to end armed conflicts. Considering that landscape, Mark Freeman, in a book that is also going to be mentioned in the chat, said that this is a difficult time to be a peacemaker. The doctrinal and institutional advance of criminal accountability did not imply the disappearance of alternative options such as Salaquet's. Eventually, those alternative options gave rise to a field of knowledge known as transitional justice. What is exactly transitional justice? According to a 2004 UN Secretary General report, which is going to be mentioned in the chat as well, transitional justice covers the full range of processes and mechanisms associated with a society's attempt to come to terms with a legacy of large-scale past abuses in order to ensure accountability, serve justice, and achieve reconciliation. Most famously, those processes and mechanisms include individual prosecutions, reparations, truth-seeking mechanisms, and institutional reforms. Although not enshrined in a particular treaty, transitional justice is promoted by international agencies such as the UN. The application of the mechanisms of transitional justice, the UN argues, should be country-specific. And here lies the tension with the anti-impunity view, because the anti-impunity view does consider prosecutions mandatory regardless of the situation. In that context, what has happened to transitional justice? That's my research question. Did transitional justice fold into the anti-impunity movement, demanding states to prosecute and punish gross human rights violations to the point that the word transitional simply wither away? To answer this question, I take Colombia as a case study. In particular, I examined the legal initiatives related to accountability for the atrocities of the armed conflict debated between 2003 and 2016. Colombia is an attractive case for studying such tension. There, several governments have undertaken peace negotiations with various armed groups to put an end to the 60-year-long internal armed conflict. It is a conflict that has caused a dreadful number of more than 9 million victims, several players, among them many international organizations acting around the globe in the fight against impunity and in promoting transitional justice, debate peace initiatives in Colombia. They interpret human rights instruments and the Rome Statute, which are part of the Colombian Constitution. Those players think that Colombia can set a precedent in the struggle against impunity. So allow me to choose two moments in my period of study, so 2003, 2016, to illustrate the different dimensions that the banner of the fight against impunity can acquire at various moments. So the year is 2011. The president at the time, Juan Manuel Santos, had not yet installed peace negotiations with the FARC, but surely with that intention in mind, Santos backed a constitutional amendment that granted Congress the power to create a true commission and a set of criminal measures delimiting the state's obligation to prosecute and punish. The amendment, called Legal Framework for Peace, provided that Colombia would focus the prosecution on the most responsible for committing the most serious crimes. Many players, such as the International Center for Transitional Justice, the most well-known organization on transitional justice worldwide, founded in New York in 2011 and with offices in Colombia since 2006, supported the constitutional amendment. In their view, transitional justice processes impose practical and political restrictions for fully realizing criminal justice. Likewise, they argue that the absence of a rational strategy for conducting prosecutions would lead to impunity. They spent considerable time explaining that the 2011 case of the massacres of El Mozote versus El Salvador, decided by the Inter-American Court of Human Rights, does allow states to use amnesties amidst peace processes. Human Rights Watch and Amnesty International, as well as domestic NGOs, reacted against the amendment, arguing that limiting the state's obligation to prosecute that way would lead to impunity. They restated that international law prohibits amnesties for international crimes and asserted that the Inter-American Court of Human Rights view has not changed over time. They rejected the idea of transitional justice as a distinctive kind of justice. In that regard, Human Rights Watch asserted in 2011 in a hearing before the Colombian Constitutional Court that transitional justice processes are governed by the same rules that apply to non-transitional contexts. Overall, in this period, transitional justice was mobilized to counterbalance a severe interpretation of the fight against impunity, according to which Colombia must prosecute and punish all responsible for committing all serious human rights violations. But at the same time, neither the government nor academics nor the International Center for Transitional Justice made use of transitional justice to defend the absence of criminal sanctions, at least for those most responsible for committing atrocities. The defense of amnesties and the use of other forms of accountability that excluded criminal justice were not even raised. My second example. Let's contrast that case with the peace agreement between the Colombian government and the FARC guerrilla, concluded in 2016. That idea was different from the legal framework for peace because the FARC rejected that amendment, arguing that it was not negotiating with them. Coming to an agreement on the rights of the victims to truth, justice, and reparations, as the point of the peace agenda discussing accountability for the crimes of the conflict was called, proved to be the most difficult of the 6 points peace agenda. Ultimately, the idea that both parties came up with consisted in creating an array of institutions and measures named Comprehensive System for Truth, Justice, Reparations, and Non-Recurrence. One of those institutions is a true commission, perhaps the institution most symbolic of transitional justice. Another one is a new court called Special Jurisdiction for Peace, in charge of deciding the criminal responsibilities of members of the guerrilla and the armed forces. That court may award several types of penalties for all those responsible for serious human rights violations. Note that the peace agreement expanded the scope of the obligation to prosecute and punish compared to the constitutional amendment studied in the previous slide. The most lenient penalty of the special jurisdiction for peace that the special jurisdiction for peace can grant is called effective restriction of liberty for those who promptly cooperate with truth and reparations and accept responsibility. Those penalties involve geographic restrictions, but not imprisonment. This point was the most contentious, motivated by the question of whether the lack of imprisonment implies impunity. Without hesitation, Human Rights Watch and Amnesty International answered yes. Human Rights Watch in particular asserted that international crimes must be punished proportionately to the gravity of the conduct and showed that the international criminal tribunals have interpreted this rule as involving imprisonment. However, this time Human Rights Watch and Amnesty International did not have much support. National organizations such as the Colombian Commission of Jurists defended the peace agreement, arguing that it guarantees knowledge of the truth. Notably, on this occasion, the International Criminal Court prosecutor welcomed the signing of the agreement and did not and said that it did not entail amnesties for international crimes. The only support Human Rights Watch and Amnesty International had, one that would bring them more problems than advantages, came from right-wing politicians who were, on the whole, opposed to the peace agreement with the FARC. So let me go to my provisional conclusions and wrap up. In the first example, transitional justice provided arguments to defend the idea that in transitional periods, justice should have a different, more limited scope than in periods of normality. In the second example, players mobilized transitional justice to create institutions and disentangle accountability and imprisonment. The use of transitional justice might seem timid when compared to the arguments made in the 90s by people like Salaket, who believed that there were accountability mechanisms other than criminal trials that were valid in some political transitions. But challenging the severe version of the fight against impunity does not seem irrelevant for those who put it forward, such as Human Rights Watch, which went so far as to describe the 2006 peace agreement on accountability as a piñata of impunity. In the examples I have included here for illustration, I mention only recognized international organizations that are representative of the competing positions on defining the impunity that a peace agreement cannot allow. Their active participation illustrates the importance they ascribe to the Colombian case as a possible precedent for the global agenda in the fight against impunity. These examples show that under the slogan of fighting impunity, there is room for a wide range of options, discussions on the type of of penalties or the use of selection criteria, for example. These discussions can hinder peace negotiations by prohibiting a seductive offer for illegal groups considering demobilization, amnesties. Hence, Mark Freeman's lament about the difficulty of being a peacemaker in these times. But the high degree of technical complexity of these debates shows that alongside the peacemakers, there are a large number of legal experts who operate with diverse discourses that make these times prolific for the profession. My dissertation also intends to give an account of the role for which I am currently conducting interviews that will allow me to understand their arguments and tactics. And I will conclude with that.
Wonderful. Thank you so much, Juan, for that very thorough explanation. And you're getting lots of great comments in the chat. We have a first question from Paul, which is about, is there anything that can be done on the question of impunity for those who have fled Colombia? And do you foresee any role that could take place to reach those folks?
In the question of impunity for those outside Colombia.
Those who would have perpetrated atrocities but have now, since left the country.
Yeah, so my answer is going to be twofold. First of all, yeah, so I guess that you're talking about the 2016 peace agreement, which is the most comprehensive regulation of the rights of victims. And there are at least two institutions who have a mandate related to that can cover victims living outside Colombia. On the one hand, the True Commission, which actually had or devoted a huge importance to connecting with Colombians living outside the country. And I understand that there were even missions or several meetings organized outside Colombia with members of the True Commission participating in those meetings to understand that phenomenon, which is a big part of the Colombian armed conflict, like people fleeing the country because of political violence. So that was one part of that. And the other is the more, let's say, criminal side of those institutions, which is the special jurisdiction for peace that I mentioned as my second example. And it has the ability to open cases to investigate situations of violence representative of the armed conflict. They actually choose either because of the theme or the victims, the cases that they open. And to this point, I think that there are around 12 or 13 big cases opened with that idea. None of them is specifically about people living abroad, but they are connected to themes that can be the reason why people fled Colombia. So I guess that there is several opportunities for participation inside the special jurisdiction for peace with that focus.
Yeah, thank you for that answer. And that leads to another question, which is these groups that are looking for, the domestic victims groups, is the question to, accountability and justice, is it compensation at this point, so many years on? Is there kind of a common thread as to what folks are asking for in terms of accountability, I mean, generally, for these atrocities perpetrated?
I think that that question is central, and I need to think better about it because, both what I presented as the anti-impunity view or those organizations who are, let's say, more punitive, like more concerned with prosecutions through criminal mechanisms, like that view, and the other that is like generally called transitional justice, both say or claim that they are the best option for protecting victims' rights. Right, so at least you have those two, like fighting for the idea that that's the best way to protect victims. So at a level of like discourse, both will be ready to claim that their views are the better option for the protection of victims in Colombia. But now I guess that you also want to know like what's the opinion of the victims. And here I think that it is very difficult to assess that, since we have plenty of victims. And when I say plenty, the official record in Colombia is more than 9 million victims of the armed conflict. And there are victims by different actors, which at the same time lead to different views about what they would want from the state. So some of them, for instance, can be a little bit more critical or less critical of a particular approach to accountability, depending on the perpetrator that we are talking about. Some of them might be more open, for instance, to a peace agreement, despite the fact of the specific terms of justice, because their main purpose of their main priority is trying to put an end to the conflict that has affected them for years. So all this to say that this is a really even I don't know if an impossible way to or maybe the best way to answer is that you cannot fight agreement, or you cannot reduce to a single position or the plurality of victims that you can find in an armed conflict like Colombia.
Yeah. Wonderful. Well, thank you very much for that thorough answer. And I understand there are more questions, and I always hate to cut people off. So as we leave, I will give the last word to our chair, Guhan Subramanian, who might wish to congratulate our fellows on their work. And we're so happy that you're with us today.
Thanks, Nicole. And most importantly, thank you to Jared and Juan Rivera. These were terrific presentations. And as Nicole said, we are grateful for your work with us this year at PON, and we really do hope you'll keep in touch as you go off into the world and pursue your academic interests and your academic careers. Thanks again.
Thank you, everyone. And we hope to see you soon at a future PON Live training or event so that we can keep continuing the journey together. Thank you. Have a wonderful day.